My Lord, I would like to say a few things, but first to tell my learned DPP, Mr. Jatiko, with the right note that he has no duty in law to oppose every application made on this side, especially if it is procedural.
Lord, I think this is grossly wrong. No one is opposed to any. No one.
We agree, my lord.
It is a matter which is the self-defense is placing it before the court. We have not known. So to say that we are opposing.
Let me finish why I said you are opposing. We are seeking for the court to halt the process until the stay application is heard. But Mr. Jatiko says, hear the plea first. That's what I heard you say. Unless if he said that the plea should be heard. Unless if I misheard him, that is where I'm coming from. That in essence is opposing the stay. Because once the plea is heard, the proceedings will have commenced. The very proceedings we are trying to stay. And this is a procedural matter. There is an application which is going to be served at the end of the day. And on a matter, like my learned friend Arias Lukwago, the Lord Mayor has elaborated, it's on matters that have been canvassed before this court, so it's not on any new matter. So I would like to refer the court to Article 28, subsection 1 of the Constitution, about the right to a fair, speedy, public hearing before, these are the two operative words, independent and impartial court, if I may leave there. That is the area the accused persons are contending. They want their petition before the High Court to agree with them, or disagree for that matter, their contention that they are not before a fair, an independent and impartial court. They have given their reasons. So this is an Article 28 fair hearing issue, and therefore the stay of proceedings is critical to that extent. We would pray, as has been canvassed by my colleagues, that these proceedings should not continue until you dispose of the stay application.
My lord, we can't have that statement expand from the record. Well, it's important to just make sure that we have a guided procedure so that we don't have to respond to each and everything, my lord.
Yes, that the petition before the High Court is to determine these issues, because the recusal was about impartiality. The reference to the court, which the court rejected, was also about the same issues. So the gist of the application, that is what is before the court for trial. I would also say it's already been canvassed that asking for 1 month is unreasonable. And I would like the court to note that although they are asking we go for plea, committal was in May this year. We objected because we had an application for mandatory bail on that day. But nevertheless, since the date of committal, we have not been served with any burdens to be aware of even what we are pleading to, even if it were to come to that. So if my learned colleagues are in such a hurry to go where when even the burdens are not with us? Because if it was the hurry for the hearing, and they should, because the trial should be speedy. to show that they are keeping to their lane and within the law, by now, without us asking, the bundles should be with us, so that the accused are even able to know what they are being asked to plead to. So I'm just asking the court to note those viewpoints, and to also reminding the court, needlessly though, that even at this court, at this chance, on your own motion, you could initiate admitting the accused persons to bail. It's within your powers.
Yes.
Especially after knowing that they are now been behind bars for 1 year. We are going to 1 year, 1 month. So even as we canvass all this, it is within your powers, my lord, to admit them to bail, especially because the sureties are before you.
My lord, for the record, Counsel Subuka Simon for A3. My lord, the petition before the Constitutional Court, as highlighted by Senior Counsel Ernest Kalibala, soundly speaks about impartiality, as stipulated in Article 28 of the Constitution. My lord, this greatly impacts on A3 as well. In that regard, A3 wholesomely does associate with the prayers of counsel for A1 and A2. And my lord, when you are pleased, we shall use the time you are going to grant to serve any further documents to the state response. We so pray.
No, my lord. My lord, my land senior colleague attempt was stating that we have no, we should, it's like we are opposing the application. And I was saying that we have not even reached there. We can't even be said not to be opposing or not.
Since we have not yet been served with.
I got you correctly. Now we are analyzing whether to take or whether to fix the other.
My lord, and that is what we are insisting.
So what I would say is that we proceed with other than
My lord, our prayer is that we proceed for plea taking. Yeah, and then formal applications can be filed, because the defense seems to be attempting to start to argue what the application is, which the prosecution has no knowledge about. My land friend, senior colleague Lukwago, said that the prosecution is lazy and they should have looked at ICMIS. But this is so absurd, because this is a new matter that has not even been served on the prosecution. It is a new matter before the court. It is not even signed. It's not even signed. So we are not tagged to this new matter, which is not even before the court. So what business do we have looking at ICMIS on a new matter which we have no idea about? I believe this is very absurd from my land friend. And in addition, the defense appears to be praying for a stay before the stay of application is had, which is wrong. And to say that when somebody has taken plea, it means the hearing has started. My lord, with due respect, a stay of proceedings can happen at any stage. It doesn't have to be that because the matter has started at plea taking. No. So, I know this court should proceed to pronounce itself.
What my colleague has said. I think my senior colleague, Elias Lukwago, the Lord Mayor, is not a Gen Z. But issues to do with IT operate in a different way. The procedure of ECNIS, which my senior colleague is submitting as if he's an expert, you have to be linked to that particular matter before you actually access it. He knows very well that we have Data Protection and Privacy Act. These are not matters for everyone. So this application, which we haven't even looked at, we don't know whether it was even filed. We cannot. Also, Brian wants to be taken to IT class. You see, this is what we are talking about, that we have not accessed that, and we have no business. We have a lot of things to do other than looking at ICNIS, where we are not actually linked to. Because whatever, if you have an ICNIS account, whatever you're supposed to see, whatever is linked to you is what you see. You don't see what has not been actually linked to you. I don't know whether my senior colleague has evidence that DPP's office was linked to this application. I just wanted to say that and waited our earlier submissions.
I think the matter before court, I understand it. It's a simple one. I'm sorry if you speak. There's an application. There's an application number 814 of 2025. When we came to court this morning, had not been endorsed by the registrar. Now it has been. What is missing is a date so that it can be signed. A very simple prayer from my colleague, Mr. Kanibala, was for court to kindly agree to fix it so that we can take service. I would want to assume that the court will seek the indulgence of this court to fix it. I'm sorry, the word might be directly, but shouldn't be. My lord, court is kindly obliged to fix it during the proceedings today. We can effect service on our colleagues because they are principal officers, so that we save time. That is the second request is that in light of the what is in the application and the petition, that court is minded have the application disposed of, and then we return to criminal session case number 355. So, my lord, before this court is an application which is pending the debt. Which we ask my lord that it dispose of in the interest of justice. And then we return. My lord, the application does not seek to nullify the criminal case. There is no such procedure. So there is no danger, there is no prejudice to the criminal case if the application is disposed. My lord, that's our simple prayer. My lord, that's the final submission. The one.